All right, good afternoon, everybody. My name is Patrick Gorman. I'm with the law offices of Bradford and Barthel in the Redding office. For all of you folks in Southern California, Redding is a very small town in Northern California, and there is a workers' compensation appeals board up here. I recently, or not recently, but about 4 years ago, transferred up to Redding, California from the Bradford and Barthel Oakland office. So my general area of specific knowledge is more centered around Northern California, from Salinas and Stockton all the way up to even Eureka. And any questions that you have will have somewhat of a leaning towards that. Some of the issues we're covering are going to be different based on the region, especially the EDD hearing reps in the various regions, because I know that in certain boards they're a little bit more aggressive than others. But again, any questions that you have, please direct them to me. And if I can't answer them, I can definitely get the information for you and shoot you an email back. As Tammy mentioned, we do have a library on the Bradford Barthel website, and I encourage everybody to go there if you need continuing education credits. And we have dozens and dozens of topics for everybody to review. If anybody is interested, I would encourage you to review the more recent topic of medical legal liens pursuant to Labor Code Section 4620 and 4622. This is an IBR issue that we've really seen a lot of emergence on. I'm sure that most, if not all of you, have been receiving demands from photocopy services claiming that you owe them all these penalties and attorney's fees. And there's a lot of information in that training. You could also view the webinar on that topic on our YouTube page. So I encourage you guys to go there. So what we are going to be discussing today is a little dry, so I do want to pre-apologize for that. But we're discussing medical benefits, temporary disability benefits, and permanent disability benefits, where a public entity, state's public entity, has come in and provided those benefits, and later we wind up having to provide those benefits pursuant to our obligations under the Labor Code. It's a unique area of law, and they aren't the standard lien claimant. They are treated a little differently because it's taxpayer funded, and they also get to write their own rules. Also, there's various overlapping sections of law, whereas the Welfare and Institution Code, the Unemployment Insurance Code, the Insurance Code, and Labor Code all interact with one another. And you'll find that there are separate remedies and obligations that you have to abide by that aren't necessarily found in the Labor Code, but rather in some ancillary code that's still applicable to our obligations. So again, sorry for the dryness. Any questions you have, let me know, and we'll address those at the end. First, we're going to start with the medical treatment series of benefits, and primarily, if not exclusively, what we're going to be addressing is Medi-Cal. Now, I do want to delineate Medi-Cal from Medicare. We're not talking about Medicare. We're not talking about their conditional payments or MSAs. That is largely a vendor-driven type industry. It's federally administered, and right now we're only dealing with benefits owed to the state of California. So medical benefits, what we will be liable are only for treatment and services to cure and relief covered under Labor Code Section 4600. We're not liable for expenses or costs borne by Medi-Cal for things that we would not be liable for under Labor Code Section 4600. So just to frame and set the stage for what benefits we're talking about here, we're talking about benefits ancillary to admitted or compensable injuries. If somebody has a history of headaches and they injure their ankle, Medi-Cal is not entitled to recover for the headaches. They'd only be entitled to recover for the ankle, things like that. And of course, there's further statutory limits on what Medi-Cal can recover. And some of these, of course, Medi-Cal would not be paying for either. I mean, Medi-Cal is not going to pay for anything other than a generic drug equivalent. However, it still should be subject to the utilization schedule, to the MTUS. It should also be subject to fee schedule. And where we have a situation, and we've seen this in Southern California primarily, where you have an injured worker who is also a Medi-Cal recipient, and they go to the doctor under their comp benefits, and you have a timely UR non-certification, and either an untimely IMR appeal or an IMR uphold of the non-certification. The person then goes to their community clinic does not tell them that they have a workers' compensation injury and gets the treatment through Medi-Cal. So again, it's reasonable and necessary. The board should not have jurisdiction to award payment for things that they don't have jurisdiction to award payment over. Also, what we're seeing with a lot of the medical treatment providers whose liens have been stayed is those liens are stayed primarily because of a prosecution for Medi-Cal or Medicare fraud, not for workers' compensation fraud. The workers' compensation fraud is subsequent to the filing of charges. So if their services are stayed upon filing of criminal charges, then I believe that our obligations to Medi-Cal also would be stayed. I don't think the board has jurisdiction necessarily. There may be questions as to whether or not a different court body has jurisdiction, but the Workers' Compensation Appeals Board should not. There's a little bit of a delay in these slides changing, so I do apologize for any delay in switching over. And we're on page 6 for those folks who are not on mine. The question then becomes, what are the rights of Medi-Cal under the Welfare and Institutions Code? What are their rights to recover? And essentially what the statutory scheme says is that they shall be reimbursed. Any publicly funded healthcare program shall be reimbursed for anything that a private care provider is liable for. And then we have to ask ourselves, what is a publicly funded healthcare program? We see a lot of community clinics that are nonprofit organizations or that are subsidized. We also have some arguments from applicants' attorneys that somehow insurance plans that are subsidized under the Affordable Care Act, they are subsidized by Medi-Cal, somehow need to be accounted for. And those are not publicly funded healthcare programs of yet. Statutorily, they have not been gathered up into the definition of a publicly funded healthcare program. A publicly funded healthcare program will be any program that is administered through the Department of Health Services. If they're not administered by the State Department of Health Services, if they're administered by a nonprofit organization, then they are not publicly funded healthcare programs. So in plain English, we have Medicare, Medi-Cal, Healthy Families, IHSS, maybe a locally operated health care center if they are charging Medi-Cal for those services. But again, these services have to be through the Department of Healthcare Services, not through a nonprofit organization that receives public funding to support their services. That is a separate entity. So at the bottom of this slide, it says that nonprofits, community clinics, etc., do not qualify. That may change, but right now we're talking about the statutory definition that we're currently addressing. Sorry for the delay again. The private healthcare coverage, so those parties who are responsible to reimburse, who shall reimburse, is essentially anybody other than the state who's liable for the Medi-Cal provided benefits. So if you are a private individual and you rear in somebody without insurance, then you can be a private healthcare insurance provider in those circumstances. Essentially, it's anybody who is liable by contract agreement or under law for the healthcare items provided by the state. So in plain English, anything administered by the State Department of Health Services is entitled to reimbursement against anybody else who would be liable. And that would be us in the workers' compensation setting. So then as we go through these slides, it's going to address statutory periods for filing notices of liens, what is a notice of lien, and what are our obligations. Essentially, Medi-Cal is entitled to subrogate. They may not only have to pursue recovery through the Workers' Compensation Appeals Board. They might have a different jurisdictional or venue, rather, to try to recover in. But what we do know is our obligations are to accept the state's right to recovery if there's an undisputed charge, that if they submit an inquiry, if they submit a notice of claim, if they're saying you owe us money, we have a duty to respond. We also have a duty to not deny the claim because they didn't file a notice for lien with the Workers' Compensation Appeals Board. In this case, and this is where they get special treatment, they don't have to file a notice and request for allowance of lien with a filing fee. They can send you a letter stating you owe us money, and that'll preserve any statute. We cannot object to payment based on the manner or format that they submitted the claim. The only thing they need to do is submit a claim to us in some appreciable form in writing, I would argue. But one can conceive that an email or even a phone message might be enough if somebody could prove that that provided adequate notice. And this is where the statute of limitations period is different. There is a statute of limitations, but they only need to provide some form of notice that they are asserting a right to recover against us within 3 years from the date of service. They then have an additional 6 years from the date of that notice to take action to recover, to file a DOR, to file a claim with the California Superior Court or the Office of Administrative Law. And this provides a very, very extensive period for them to recover, and it worries definitely claims adjusters who want to have their files closed and not have to pull them out of storage 9 years later to assign out or somehow negotiate a lien when the applicants cash their check, the doctors have cashed their checks, and the reserves have all been reassigned. So there's some steps that we're going to discuss in order to protect ourselves from that happening, but that's really what is giving concern. And I just want to say, a footnote to the next few slides here, what we're seeing statewide is a change in policy from Medi-Cal, and that's why we're discussing this. Medi-Cal has been sending notices to carriers that are not notices of liens, but rather they're getting some kind of hit or match between EAMS or the Workers' Compensation Board or the Department of Insurance. I'm not sure where they're gathering these socials, but somehow the socials are being matched up in their system. And if they have a match between Social Security numbers and they've ever provided any benefits to that person, they're sending letters to insurance carriers asking them to log on to the Medi-Cal website and complete all the information. And this is where it gets into a policy versus legal discussion. And I want to make sure that everybody understands that the internal policies of your respective employers, of your company, are going to prevail over what your legal requirements may be. So the legal requirements may be at one level of threshold where the internal policy decisions of your management team and directors are going to be possibly more favorable to Medi-Cal. And you're going to have to definitely speak with a supervisor if you have not already been notified of their policy with regards to these letters that you're receiving from Medi-Cal. But what we need to always know and be aware of, and I don't think everybody at Medi-Cal is aware of this, that they are only entitled to reimbursement for treatment that is covered under a workers' compensation injury. So again, it has to be a compensable body part. It has to be within the scope of the injury. It has to be something that was not timely denied by UR, non-certified rather, and something that the board has jurisdiction over. And it has to be payable at fee schedule, or there has to be some kind of applicable rebuttal. Most of the time, anything Medi-Cal pays, I think everything they pay would be at the same fee schedule. But again, these are only items that we are liable for. We do not have to pay Medi-Cal for every service they provide, only for the services they have provided that we otherwise would have been responsible for. So again, just to cover the ground rules, the framework of what our obligations are, Medi-Cal must submit a claim within, not file a lien, but submit a claim within 3 years from the date of treatment. And it's any notice of their right to recovery. Notice of potential Medi-Cal lien, that was what I'm discussing, and we'll look at that in just a moment. And our legal opinion does not constitute a claim or notice of lien. A notice of claim must be communicated. They must say, you owe us money. We have a viable claim, not, hey, fill this information out because maybe you owe us money. It needs to be more definitive. But again, we're going to defer, and you're going to defer to your management team's policy on this issue. Upon receipt of a claim from Medi-Cal, so long as the claim is submitted within 3 years from the date of service, you must respond. If they say you owe us money, you must respond. They have 6 years to take action. But I think that simply by notifying you of their right to recovery and your failure to respond to that notice would toll any 6-year statute of limitation to take action. Okay, this next slide that is going to come up is going to show the different documents, and that's what has really begun the process of this training and the basis for this specific portion of the training. On the left, you'll see a letter that says Notice of Potential Medi-Cal Lien. And on the right, you'll see a letter that doesn't have any scary header and all bold and capitalized. It's just simply saying, you owe us money. The letter on the right, the document on the right, was accompanied by about 37 pages of invoicing for medical service provided. On the left, there was just a second page with a signature. You'll note on the left, they're saying, this is a notice of potential lien. Please go onto our website and complete all the information. And I don't believe that there's any obligation legally for you to go on and complete this documentation. It may be beneficial in some cases to complete this documentation. We'll cover this in a little bit, this last statement. But legally, if you do not respond to this notice of potential Medi-Cal lien, I do not believe that would justify any tolling of that 3-year statute of limitations. When you get a letter like the one on the right where they say, you owe us money, here are invoices, that is a notice of lien. And again, I want to differentiate the terminology that I'm using. Notice of lien is not the same. It's not synonymous. It can be a notice of request for allowance of lien filed at the Workers' Compensation Appeals Board, but it does not need to be. The letter on the right is sufficient to preserve their statute and jurisdiction to recovery. So then a lot of issues that come up in this, most of the time these are coming up after the case has been settled for some time, are, well, I have a Thomas finding, and a Thomas finding prevents me from having to pay anything in the future, and that is not correct. There seems to be a broad misunderstanding as to what Thomas means. I've had to litigate this with co-defendants on subsequent recovery through contribution reimbursement, and the prevailing thought is that Thomas is some impervious force field that prevents you from having to pay benefits. That's not true. Thomas only pertains to vocational rehabilitation benefits. And there's been life breathed back into Thomas. In 2004, Voc Rehab was redacted from the Labor Code, and we had some supplemental job displacement voucher obligations, but they were largely settled out within compromise and release agreements and not utilized. Now we can no longer settle out the job displacement benefits. They must be provided pursuant to changes in the Labor Code under Senate Bill 863. So we have a situation where this recently went up to the recon unit, and they said, if the claim is denied, you can get a Thomas finding. However, that's only going to apply to the voucher, not Medi-Cal's right to recovery. So we have case law to support this. We know that medical legal liens, QME liens, are not prevented or precluded through a Thomas finding. We also know that illusory Thomas findings are not viable if it's a bare assertion and it's not supported by the medical reports or information in the file, then it's worthless. The burden with Thomas, or with a denial rather, I mean that's what Thomas arises out of, is settling a claim with a denial. The burden is still on the party attempting to recover to prove injury. So if you don't have a compensable QME report or you have a viable affirmative defense, Medi-Cal still would have to somehow prove they were entitled to recover under the first 90-day period of treatment, or that the affirmative defense is not viable. They would have to go to trial and rebut that affirmative defense. You can put things in your settlement documents to support your affirmative defense, but a lot of settlements that I've come across simply say this claim is denied and subject to Thomas, with Thomas underlined, and that is the extent of the enumeration of why the lien claimants or Medi-Cal, in this case, are not entitled to recover. So I want to caution people that simply reciting Thomas as a case is not going to be enough to keep you out of court, and it may not be enough to prove Medi-Cal is not entitled to recover. The board will still have jurisdiction. So how do we protect ourselves from liability? How do we put this language into our settlement documents so that when Medi-Cal comes back 2 years after your CNR, or possibly 6 years after your CNR, and says you owe us money, and you say, hey, no, this person's injury pre-existed our employment, or this is subject to a viable affirmative defense, we don't have to pay for their psych treatment because this was a good faith personnel action. How do we protect ourselves? And also, how do we protect ourselves when there's open medical treatment? How do we keep Medi-Cal from grabbing our body parts and bringing them into benefits they're treating for, the body parts they're treating for? How do we prevent our left shoulder stipulation from being pulled into a subsequent neck injury? And the best way to do that is to be more specific in your settlement documents. When in doubt, you can always contact Bradford Barthel or another law firm and ask them to help you with language in your settlement documents. But we need to be more specific as to what we are settling or what we are denying. If we have open medical, we need to be specific. If it's the L5S1, we need to say L5S1. If it's the low back, we need to say the low back instead of the entire back. If it's the ulnar nerve, we need to say ulnar nerve instead of elbow. We need to be more specific and make sure that the body parts stipulated to are confirmed in the medical legal reporting, and only those body parts that are confirmed by the medical legal reporting, not generalities. And I've also seen situations come up with Medicare where they've denied treatment for subsequent injuries and tried to bring non-covered body parts into the workers' compensation realm. So we're seeing policy changes. We're seeing government agencies aggressively trying to find savings by pushing liability off onto insurance carriers who have open medical awards or other liability. Also, you want to ensure that you always state that the body parts that are not referenced are denied. You want to just simply state that all other body parts are denied. Medi-Cal does not have an absolute right to recovery. Because they're the state and because they make their own rules, they do have special rights, but they don't have the right to recover for anything. If there's self-procured treatment, like I mentioned before, where we have a timely UR non-cert and they go outside of the comp system because they want the treatment anyways and Medi-Cal pays for it, the board may not have jurisdiction to award that and Medi-Cal may not be able to recover. You should always include Thomas language in a CNR. And I don't mean to disparage Thomas in saying we should not state that there's a Thomas finding if you have a denied injury, but you need to have specific basis to support your Thomas finding and any settlement with a denial. Again, if somebody filed an application or filed a claim form rather after they were terminated and there's no medical evidence of any injury prior to their termination, state that. Simply state that in an addendum or in Section 9 of the Compromise and Release Agreement. Addendum are very useful, and I have some addendum that are form addendum, but you don't hesitate to add additional language to the addendum. The addendum provide minimum language, but you should always consider modifying or adding to that language for each specific case. Also state which body parts are not compensable. If somebody has a right injury that's admitted and they claim they have a compensable left shoulder injury from overuse, and that injury is denied, the left shoulder is denied, simply state it in the settlement, even go so far as to state the parties stipulate that that body part is not industrial. Any findings of non-compensability, again, addendum in the actual order approving compromise and release. So reference the actual finding of non-compensability in the order approving, not just in the compromise and release agreement. And I understand that there's pushback from the judges and the Workers' Compensation Appeals Board about some of this. I understand that some judges will not allow you to be as specific as you might want to be, and they'll want to amend language, but we should always start from our strongest position, and maybe we can compromise on some of the language, but let's try to make sure that we go in with the best language possible first, and then work from that. Let's not limit ourselves or expose ourselves to more liability by assuming the judge may do this or that when they review the settlement documents. The next slide is going to provide just some brief examples of exculpatory language in settlement documents. On the left, you'll see a stipulation with open award, and it is very specific as to what body parts are involved, what parts are denied. So in this case, the body system, respiratory system, skin, and death, the liability is denied for those injuries. On the right, sorry about the redacting with the marker. I'd add some language, but if you have a co-defendant and you guys have knowledge or you believe there might be some ancillary treatment issues, if there are lien issues or Medi-Cal issues, have the other part, if we're putting money on a CNR that or a stipulation that we otherwise would not be liable for, make sure that they hold us harmless. Make sure that they are the ones who have to litigate. Keep in mind that when we have joint injuries. We are joint in several parties. So if the other party were to go into liquidation, for example, then nothing precludes Medi-Cal from litigating against the co-defendant simply because the target defendant says, hey, I'll pay this. We need to make sure that we have exculpatory language, that we are held harmless by any co-defendant if they want us to participate to the extent of a nuisance value in a settlement. Again, we also need to make sure that this is supported with evidence or not, I guess more importantly, not rebutted by evidence. If you have an AME or a QME who found liability against you and you put this language in there without some kind of facts reference to support why your agreement is different than the medical legal evidence, then it's difficult to reconstruct that 4, 5, 7 years down the line. I think that another topic we need to broach on this, and something that needs to be considered, is protecting yourself from liability while the case in chief is pending. If you know that somebody has Medi-Cal entitlements or is going to seek Medi-Cal treatment and you've denied treatment, or even Medicare to this extent, let that publicly funded benefit provider know that you have a compensable injury so that they don't pay for the injury, so that they don't provide medical treatment. There's nothing wrong with being preemptive and proactive and contacting Medi-Cal or Highland Hospital or the community hospital and saying, no, listen, there's a compensable injury here. I have to provide benefits. Do not pay for medical treatment. And they may not. They should not. Again, I mean, any treatment that they're entitled to under the workers' compensation system, they're going to have to go through the labor code and be subject to the labor code in order to recover. I would also let applicant's attorney, in writing always, know that if they are venturing outside of the workers' compensation system, that it's self-procured and you're objecting to any treatment. Make sure that when you file an answer, you object in the answer to any self-procured medical treatment so that that preserves your right to dispute it later. If somebody ignores, an applicant's attorney ignores your admonishments and Medi-Cal is still providing medical treatment, file for an expedited trial. Get an order stating that you are not liable for treatment if they're just simply doing an end around because you are exercising your rights under Labor Code Section 4610. And also always consider the potential Medi-Cal interest in the case. Maybe it doesn't make sense to go to a QME. If you have an affirmative defense, but the QME is going to find injury, or you think the QME might find injury, and you can secure a settlement before that medical legal report issues, giving Medi-Cal ammunition to recover against you, maybe that makes the most sense. These are all things to consider when settling the case. So that concludes the Medi-Cal portion and the portion that we're really seeing a lot of new movement on. We're going to now move over to temporary and permanent disability benefits. These are benefits that we see issues arise out of the Department of Child Support Services in the form of income withholding orders and child support liens, and most commonly the Employment Development Department and their 3 areas of benefits. Here's a brief recap of TD. We don't need to cover it. Everybody knows that there's minimums, maximums, statutory periods. Everybody also, I hope that you're aware, there is a board decision that came out some 6 months or so ago stating that the 5 years from date of injury is the absolute cap to temporary disability benefits. If somebody is not TD until 4.5 years after their injury, they're only entitled to 6 months of TD, not 104 weeks. And that is settled law now. There are some enumerated cases, massive burns, amputations, traumatic brain injuries that extend the 104-week period to 240. Permanent disability is a similar calculation. There are different minimums and maximums. One thing that we're going to see in these slides and what has come up is where you have child support obligations, you have an income withholding order, somebody's temporary disability benefits run out, and they are now entitled to permanent disability advances. And do you pay permanent disability advances in the face of that income withholding order or child support lien? And you have applicant's attorney threatening to file for penalties and attorney's fees and everything. And what do you do? And we'll cover that in a moment. But again, we don't need to go in detail over everything about these benefits. They're all clearly defined by statute. What are the reimbursement rights of EDD? This is another area where you have an overlap between different statutory areas, and the Unemployment Insurance Code defines the reimbursement rights of EDD. and this is something ancillary to the labor code. So if essentially EDD provides benefits and an insurance carrier subsequently assumes liability for those wage loss periods, then EDD is entitled to reimbursement. Some things that are scary in this section of the Unemployment Insurance Code is that any failure to reimburse is subject to a 10% penalty in addition to the reimbursement amount. And this is separate from Labor Code Section 5814. So they can, and it's not in addition to Labor Code Section 5814. It's separate from 5814. So there may not be an unreasonable delay in providing the injured worker benefits, but if you, and I see this commonly, less commonly now, but for some reason, EDD's right to recovery does get put off until the case in chief is resolved. And then we try to negotiate EDD's right to recovery. And at that point, there is a potential risk for penalties. EDD is not exercising their right to recover penalties under the Unemployment Insurance Code, but nothing other than their policy decisions is preventing them from doing so. And I think a lot of this is also just under training of the EDD hearing representatives. But all it's going to take is one supervisor to decide they're going to seek the 10% penalty, and there'll be a separate situation. There's also interest in addition to the penalty. And again, we're seeing EDD waive this issue a lot, but at some point, all it takes is one person to change their mind and tell all of the hearing reps that they are no longer waiving penalty and interest, and it's going to cause a lot of issues on these claims. So as we'll discuss in this section, when practicable, reimburse EDD. And then there's additional reimbursement rights to EDD under the Labor Code. And this is where you have a separation between the species of benefits that EDD provides. EDD provides disability benefits, unemployment benefits, and FMLA, family leave benefits. And they're entitled to different recoveries against different species of benefits. So in short, I believe there's a plain English slide here, but in short, temporary disability benefits, EDD is entitled to recover for any benefits they provided. So if they provided disability, unemployment, or TD, not TD, FMLA, they are entitled to recover against periods of TD. However, as you'll see, permanent disability advances, or PD itself, is only recoverable by EDD for periods of disability, not unemployment or FMLA. So what are our obligations? Upon receipt of communication from EDD claiming that they're entitled to reimbursement, similar to Medi-Cal, we have to communicate with them. We have to respond, and they are entitled to recovery against any temporary disability benefits for no matter what benefits they provided. If there are overlapping periods of TD, they are entitled to recover. And I know that somebody on this conference call right now is thinking, well, hey, what about unemployment? If they're saying they're entitled to unemployment, they're certifying that they're entitled to, or that they're able to accept gainful employment. Well, when you have a medical report saying that they are TTD, then there's a conflict there, and EDD may have a right to recover. There's an argument maybe that they're not entitled to TD benefits if they genuinely could have accepted work, and in that case, then EDD wouldn't be entitled to recover. But if there is a period of temporary disability that's not in dispute or found by the board that overlaps with any benefits provided by EDD, EDD has the first right to recover, I think only after attorney's fees. Attorney's fees are for the only person who can recover in front of EDD or the state. They're only entitled to recovery up to the actual TD rate. There will be differences in calculations. Sometimes when people receive a lot of overtime in one quarter or bonuses, the EDD rate will be much higher based on that quarter of earnings because they take the highest quarterly earnings to amortize over 52 weeks, where we take the entire 52 weeks. So make sure that you're not reimbursing EDD at the EDD rate, but rather at the TD rate. If the EDD rate is lower, then they don't get the difference. That difference goes to the injured worker. Only SDI benefits, only disability benefits are reimbursable against permanent disability. So no unemployment and no FMLA. Again, getting into our obligations, there are more than just paying EDD. We have additional timeframes as if you did not have enough. We are obligated by law to notify EDD in writing as soon as possible, but no longer than 3 working weeks, 15 working days after commencing disability payments. So a TD, PD notice, some form of notice needs to go to EDD within 3 weeks of initiating those payments. That way they can act to recover. Ideally, you would know EDD has a right to recover and you would negotiate with them their recovery, or at least do some form of good faith calculation to keep that money aside in trust until you can work it out with EDD. I know EDD is not the most responsive. However, they are present at every workers' compensation appeals board. There is a hearing rep on site. If you have an issue that needs to be squared away with EDD, I encourage you to have an attorney who is going to a hearing for you or doing a walkthrough for you to also talk to the hearing rep at the board on whichever cases you need to discuss, or at least get an email for the EDD hearing rep or some way for you to communicate with them. That is one way around simply making a phone call and waiting forever for them to never call back. When a lien has been served, when EDD has filed their lien, EDD must be served or notified in writing within 2 weeks of any filing an application, an award, CNR with the appeals board. So if you're going to walk through some settlement documents and you are filing them, they need to be served on EDD if they filed a lien. The settling a case in the face of an EDD lien or child support lien for that matter, you are holding the injured worker harmless. So the judge can approve it, but you will be liable ultimately if the injured worker received overlapping benefits. We've all seen injured workers cash TD checks and EDD checks at the same time. And if that happens, EDD will be entitled to recover against you because you settled in the face of the lien. So let's make sure that any settlement, my rule of thumb is whether there's a lien or not, I always contact EDD just to make sure. Keep in mind the penalty provisions under the Unemployment Insurance Code. There are penalty and interest provisions. Any failure to abide by these timelines, or if you want to wait until the end of the case to settle EDD's interest when you have notice of their interest, they may not be exercising their right to recover this penalty and interest, but that can change at any moment in time and could be retroactively applied. Here's another summary. Again, it's there for you to review and have in writing. But again, another thing we need to be mindful of are the species of benefits we're providing versus the species of benefits EDD provided. And we'll see this more on the child support issue. But again, TD goes to any benefits that EDD provided, and PD only goes to disability. Okay, so next we're going to discuss child support and spousal support. This is an area of law that has not been really fleshed out by the Workers' Compensation Appeals Board, and the case law addressing this states simply that this is an area of law that is not widely understood. We have 2 different means of recovery for child support benefits and spousal support benefits, or just child support benefits and potentially spousal support benefits. They can file a lien pursuant to 4903E, but it doesn't have to just be the state. In my research on this issue, I found that employers giving deferred compensation can recover against workers' compensation awards. Landlords who have waived or there's back rent for, they can file a lien. Spouses who have not been receiving their alimony payments can file a lien. And also a mental hospital can file a lien for the room and board. Essentially, it's any living expenses would be subject to Labor Code Section 4903E, and we don't know the extent of recovery, if it's just against permanent disability, temporary disability, or if it could also be against settlement of future medical. So this is out there. Liens for living expenses can be filed, and whenever there is an actual child support lien, it's subject to 4903E, and there's a different right to recovery. Most of the time, though, we will see income withholding orders. Income withholding orders are different than liens with the Workers' Compensation Appeals Board. And the Department of Child Support Services can file both. However, it gets very complicated as to the extent of their recovery. So income withholding orders are only recoverable against temporary disability. If you've paid 104 weeks of temporary disability and you've been withholding pursuant to an IWO, and there is now permanent disability advances that must be awarded, then the Department of Child Support Services may not be entitled to recovery, but they also may. they may be entitled to recovery if they filed a lien. And at this point, it becomes very hyper-technical, and I recommend you get an attorney involved. But we really start parsing out what benefits the person's recovering, the injured worker is recovering, versus the means that the Department of Child Support Services has exercised to recover the arrearages. And we also are going to see that it depends on when the arrearages occurred. The Department of Child Support Services may file a lien in any workers' compensation case. And any award under the Family Code is allowable. There's no basis to rebut those Family Code awards. So if somebody has a $350 a month child support obligation, the Workers' Compensation Appeals Board found that they cannot amend the Family Code award, the award out of the family courts of that $350 a month. There can be pre-injury arrearages awarded against temporary disability benefits. A lot of the IWOs we receive are subject to pre-existing arrearages, arrearages that existed prior to the injury. And there's a different right to recovery for those pre-injury arrearages versus arrearages occurring after the injury. Temporary disability benefits covers all right to recovery by child support services, or I should better state that as the Department of Child Support Services has a right to recover for any benefits they're owed, any money they're owed against temporary disability payments. And that would be subject to the income withholding order. It's no more than 25% of outgoing temporary disability. Footnote to this, and I've had to deal with this a few times, is when you have multiple IWOs through multiple counties. Every county administers their own child support services obligations and recovery. And you'll have a situation come up potentially where you'll have a person, an injured worker who has 3 separate children in 3 separate counties from 3 separate significant others. And there will be 3 separate income withholding orders for various amounts, and that amount together far surpasses the 25% of temporary disability. In that case, what I recommend you do is you hold the money in trust, you contact the Department of Child Support Services, they do have a state number, and you tell them that you're going to pay one central location, and then they can allocate the money accordingly, and you want to get this in writing. So that's a potential that's a footnote to this situation and a way to handle that. There's no reason why you need to put yourself in a penalty situation because the state is cumbersome and there's a lot of bureaucracy and red tape. I would contact one and make sure one department, one county, or the state itself takes one check and then they distribute it through the state disbursement unit. So then, again, where things get complicated are child support and withholding orders against wage loss versus permanent disability. Again, against temporary disability, either an income withholding order or a lien can be subjected to recovery against TD, but in no event more than 25%. And the reason I keep hammering on this is if you know there's a child support obligation, simply set it aside and you haven't worked out how it's going to be paid, you don't know, you haven't received any callback from the state, keep that money aside in a separate account or keep it in trust. Do not pay that to the injured worker or to their attorney. Keep that separately so that you can then pay it to the state later once everything is worked out. If your delay in providing the money to the state is reasonable because they don't call you back, as long as you keep that money aside and you don't pay it to another party, everything will be all right. But if you pay the applicant all of their TD benefits in the face of a lien or income withholding order, there's a good chance that you're going to wind up having to pay the Department of Child Support Services, that money in addition to the TD the injured worker received. So then where this gets really opaque is how child support and other obligations under Labor Code Section 4903 are treated. And this first bullet point states exactly what all of the treatises state, that there's been little case law interpreting the precise language used in this subdivision since 1937. In other words, we don't know exactly the extent they have to recover. We know that this only applies to post-injury arrearages. We also know that it would definitely apply to permanent disability. We do not know if child support arrearages that occurred post-injury and subject to Labor Code Section 4903 would be subject to recovery against the remainder of, well, at least the future medical provisions in a compromise and release agreement. So any money that would not be allocated to future medical treatment, they would be able to recover. I don't think there's much of a dispute there. Where the vagueness is, you have a CNR, and let's say it's a $50,000 CNR, and you have 25 allocated to PD, and you have 5 allocated to non-medical issues such as rights to reopen, and then you have the remaining 20,000 for future medical. What does the Department of Child Support Services get to recover against under that scenario for post-injury arrearages? We know that pre-injury arrearages would not be entitled to recover against anything other than temporary disability. So the question becomes whether that 20,000 future medical buyout would be subject to the lien, and we don't know. I believe that the board would lean towards it not being recoverable. However, the judge is going to have a hard time making that call. In these situations, that is when the judge needs to make the decision. And I don't think there's anything wrong with filing this matter for a hearing, setting it for trial, and having the judge determine whether or not this 4903 lien is recoverable against the $20,000 future medical award in that scenario. So you'll see a scenario A, and you're going to see a scenario B here. So we're running a little short on time. This is a very complicated scenario where you have pre-injury arrearages and an income withholding order, and you have post-injury arrearages with an income withholding order and a lien. And the question becomes, what do you do? The TD payments, we already know, we're going to set aside 25%, and that's going to the Department of Child Support Services. But what happens with the permanent disability advances? Well, if we know there's post-injury arrearages, then 25% of those PDAs, at least 25%, if not all of those PDAs, are going to be allocated to the Department of Child Support Services. And in these situations, that is when we need to file a declaration of readiness to proceed and allow the Workers' Compensation Appeals Board to flush out what the precise language of this subdivision means. They haven't flushed it out. They haven't interpreted it. Maybe it's time they do so. So when in doubt, always seek clarification from a judge. If you timely file a DOR, if you have this issue arise and you file a DOR, you can send a PD delay notice, file a DOR, and as long as you are acting diligently, it would not be subject to penalties pursuant to 5814. Allow the judge to know, listen, there is a good faith, legitimate issue as to what recovery the Department of Child Support Services has in this case. And we know that the treatises say there is no case law interpreting what it means. So judge, I'm sorry, but now it is you need to interpret what the language means, and they'll probably send you to another judge. But at the end of the day, you are acting diligently. You are not in a penalty situation by delaying PD so long as you have a good faith dispute. The problem is if you pay PDAs, if applicant's attorney rattles you and you get scared that applicant's attorney is going to run up the bill and charge you $6,000 in attorney's fees, and you pay the PDAs in the face of this child support lien, where you know there are post-injury arrearages, then you might have to pay overlapping benefits. Joe gets his PDAs, and the Department of Child Support Services gets the equivalent of those PDAs. Strategies, ways to deal with this other than filing a declaration of readiness to proceed, because again, we're not going to do that unless we know there's a good faith dispute. And we need to know when there's a good faith dispute. We know that a lien and an income withholding order are different. An income withholding order attaches to temporary disability only, and it can apply to current obligations and arrearages accrued before the date of injury. We know that a lien under 4903, it attaches to TD and PD, but it only applies to PD for arrearages that are subsequent to the date of injury, and never settle by stipulation and award or compromise and release in the face of a child support lien, because if ultimately they are entitled to recover, you're going to have to pay additional money that should have been deducted from the award or from the CNR to the Department of Child Support Services. And that's a situation nobody ever wants to be in. Make sure that you file a DOR in this situation and you issue the requisite delay notices. If there's an income withholding order that may be enough for you to know that there are arrearages. If you know that somebody is obligated to pay $350 a month in child support, and you're only sending $75 a month to EDD, I guess it would be a week, I'm sorry, $350 a week versus $75 a week, you know that there's that arrearage occurring from the date of injury going forward. That may be enough for you to anticipate a child support lien, for you to not wind up in this situation. So if you know you are not satisfying the entire IWO with the temporary disability reductions, then that puts you on notice that there are post-injury arrearages, and you need to take steps. At the end of the day, the judge is going to have a harder time telling the applicant that his award is going to be reduced than telling the insurance company that they have to pay extra money. And ultimately, the state is going to recover whenever they're entitled to. Child support liens currently, I do not believe, apply to future medical care or settlements of future medical care. However, there is not a case supporting that. I just believe that the practicality of it, that is the situation. No, the state has no right to recover against a CNR's future medical care provisions for any other benefits. So I don't know why they would be entitled to do so for child support liens. Again, I appreciate everybody's time. I know this is very dry material. At this time, if anybody has any questions, please let me know. If anybody has any questions that they can't think of now, they think of later, or that maybe are a little bit longer and they'd like to submit in the form of an email, please email me. It looks like there are a couple of questions that I'll address now, a handful here. I'll hand that over to Tammy, who's going to read them, and then I'll address them. But again, I just want to encourage everybody, if you have a question regarding this, or any issue for that matter, whether there's going to be a file sent my way or not, email me. I'm always dealing with these issues, and we all learn from dealing with new issues as they arise. So I encourage anybody to shoot me an email or give me a call. My email is pgorman, G-O-R-M-A-N, at bradfordbarthel.com. And with that, I'll hand the questions over to Tammy.
Hi, Patrick. Thank you so much. We have a couple of questions. The first one, if we continued to pay TD and child support withholding in good faith pending a permanent and stationary report, why are we not allowed to seek recovery for the overpayment from child support?
Okay, so I'm reading this right now. I just want to make sure I understand the question. Okay, so this is a little bit more of a complicated question because it brings in the board's interpretation of Maples and J.C. Penney. And what Maples and J.C. Penney state is that generally temporary disability payments are allowed. They then go into, it's discretionary for the judges to allow them or not allow them, and speaks to notice. So in this case, if you're paying temporary disability and withholding for child support, after a QME evaluation for that 30 days or so while you're waiting for the QME report, the reason why you would, I suppose you could recover, I suppose you could recover over whatever you paid to child support, because that's still from the TD pot, right? So we'll use simple numbers here. Let's say that your TD is 400 and you're sending 100 to child support. And should you only be entitled to recover the $300 as an overpayment? No, you'd be entitled to recover the entire 400 in that case, if you're allowed the TD overpayment. Now, you'll never get the money back from the Department of Child Support Services. You're going to have to get it from the CNR. But again, those TD benefits are still TD benefits. It's just being withheld. It's being allocated to another party as well. So any temporary disability overpayment would be subject to a credit, no matter how much of it was sent to the Department of Child Support Services. I hope that answered your question, but sorry, it took me a second to unravel it here. That is pretty complicated. If you are aware of any judge who has said otherwise, I'd be very interested to hear the rationale for it. But again, if you're entitled to a TD overpayment, you'd be entitled to the entire TD overpayment, no matter how it was allocated. Okay, and there are a couple more here, Tammy.
Yeah, I get one more. How does UR apply to CMS liens since the treatment has already taken place?
Okay, so this is dealing with Medicare. ultimately UR would not apply to CMS because the state has no jurisdiction over the Center for Medicare Services. There's a complete separation of jurisdiction. The Workers' Compensation Appeals Board cannot touch it, and nor can CMS. I've never seen CMS come into the Workers' Compensation Appeals Board to recover conditional payments, and why would they? The due process that they have set up, CMS, that the federal government has set up for Social Security and Medicare benefits, is the bare minimum threshold for due process. Essentially, they are entitled to, by simply availing yourself to, or not availing yourself, but availing them to reviewing your waiving any jurisdictional arguments, and they get to handle the entire appeals of their own decisions. So, yeah, the simple answer is UR would not apply to CMS because UR only applies to the Department of Workers' Compensation, the Workers' Compensation Appeals Board, and the Labor Code. CMS is not subject to any provision of the Labor Code because they are a federal entity, and the preemption clause in the Constitution would disallow us from any of that. You can argue through a vendor or whomever that the treatment CMS is trying to recover, they wouldn't have been entitled to recover it, but at the end of the day, CMS is ultimately going to be making that decision under their conditional payment appeals process, and you're going to have to deal with that through a vendor. And if, Kim, again, that was your question. If a printout of the slides, I would be happy to email you a copy of the slides. I believe that there's also on our website a link to it, so you could print them out there. But shoot me an email if you ever have any questions. I have not worked up training on CMS. It's such a vendor-driven industry and subject to so much change and interpretation that it might be a little out of my comfort zone. But again, I'm glad that was good, that your question was answered. And also, I do see another one, Tammy, from Kathy. Do you see that?
Okay. Yes. EDD is always changing their numbers, like they are trying to avoid our calls. They never post their updated numbers.
I know, and even more so at certain boards. Fresno comes to mind. The EDD hearing reps are worse than half the lien claimants out there. They feel that if there's no argument they're entitled to any recovery, they're going to stand in the way of a CNR unless they can shake you down for $1,500. And it's very frustrating. They don't have an obligation to provide you with the accurate numbers. My suggestion, Kathy, is to have your attorney, who's going to be at the board for you anyways, stop in and grab EDD's attention and work through whatever you can work through. If you can ever get a hearing rep at EDD or at any department of EDD to respond to your emails, that right there is gold. If you can have an EDD rep who will respond to your emails and help you out, then that's a great contact to develop. So if, as you do get somebody on the phone and you finally do talk to an EDD rep, ask them for their email address and ask them if you can contact them regarding other matters. But the most efficient and expeditious way to get the attention of EDD and work through these things is to have your attorney, who's already going to be at the board for you, talk to EDD on these issues. And you know, that's something that I've always gone out of my way to try and do, because as a newer attorney, I had to go back to the board on my own time so many times to talk to EDD about a lien I didn't know about when I walked through the CNR. So now if I ever have an issue, I always, actually up here in Reading, it's a little bit more frustrating because they don't have hearing reps at the board. They're remote, so it's a little bit more difficult. But when I was in Oakland and San Francisco, especially in the Oakland office, I would walk the 3 blocks to the board just to talk to EDD about a case if I had a repayment issue and needed to work it out with them. But at the end of the day, what you're going to do, Kathy, is you're going to keep that money set aside and not pay it to the injured worker until you can work it out with EDD. And as long as you act diligently and you show that you made good faith attempts to square up with them, there won't be a penalty situation.
Okay,
all right,
great.
I think that is all.